हाय हेलो वेलकम एवरीवन। कैसे चल रही है आपकी स्टडीज? आई एम श्योर अच्छी चल रही होगी। और आज हम लोग एक इंडियन कॉन्ट्रैक्ट एक्ट का क्विक रिवीजन ले लेते हैं। इंडियन कॉन्ट्रैक्ट एक्ट में क्या क्या चीज़ें आपको पता होनी चाहिए। वेल, डिफाइन करें तो बेसिक चीज़ों से शुरू करते हैं। व्हाट इज द कॉन्ट्रैक्ट, व्हाट इज द एग्रीमेंट, व्हाट इज द प्रॉमिस, व्हाट इज द प्रपोजल। जब हम बात करते हैं किसी भी तरीके की प्रॉमिस की, जब हम बात करते हैं किसी भी तरीके की एग्रीमेंट की या एक कॉन्ट्रैक्ट की, तो उसमें क्या क्या चीज़ों का ध्यान रखना है। वेल, एन एग्रीमेंट विच इज एनफोर्सेबल बाय लॉ इज अ कॉन्ट्रैक्ट, ये वेल नोन फैक्ट है। बाकी एक अग्रीमेंट की बात करें तो एवरी प्रॉमिस एंड रेसिप्रोकल प्रॉमिस शेयरिंग कंसिडरेशन फॉर ईच अदर, तो वो एक तरह का अग्रीमेंट है। मतलब दो पार्टीज आपस में अग्रीमेंट कर रही है। जब आप एक प्रॉमिस की बात करते हो, प्रॉमिस का मतलब होता है वेयर वन पर्सन सिग्निफाइज टू अनदर इज विलिंगनेस, वो एक तरह का प्रपोजल है। और ये प्रपोजल जब दो जन साथ में प्रॉमिस करते हैं तो वो एक तरह का प्रॉमिस बन जाता है। वही प्रोमिस व्हेन वन पर्सन हैज एक्सेप्टेड द प्रॉमिस एंड अदर पर्सन इज गिविंग द प्रॉमिस, वहीं पे वो एग्रीमेंट बन जाता है। So when one person signifies to another his willingness to do or abstain from doing something with the intention of obtaining the assent of the other person or to that of his abstinence, it is that to be a proposal. ठीक है, फाइन। अपार्ट फ्रॉम दैट दूसरी चीज याद रखना, व्हाट इज द एसेंशियल ऑफ अ वैलिड कॉन्ट्रैक्ट। वेल, एक वैलिड कॉन्ट्रैक्ट के अंदर ऑफर एक्सेप्टेंस होता है, फ्री कंसेंट होता है, म्यूचुअल एग्रीमेंट होता है, लॉफुल कंसिडरेशंस होता है, एनफोर्सेबल बाय लॉ होता है, पार्टी शुड बी कॉम्पिटेंट टू कॉन्ट्रैक्ट होना चाहिए, ऑब्जेक्ट हमेशा लॉफुल होना चाहिए एंड सर्टेनिटी होनी चाहिए परफॉर्मेंसेस होने के लिए। देन नेक्स्ट क्वेश्चन, दैट इज एक एग्रीमेंट और कॉन्ट्रैक्ट के बीच में क्या फर्क होता है। वेल, अगर आप बात करो एक एग्रीमेंट की, एग्रीमेंट एंड क्या होता है, एवरी प्रॉमिस एंड सेट ऑफ प्रॉमिस फॉर्मिंग कंसिडरेशन फॉर ईच अदर इज अ एग्रीमेंट। लेकिन कॉन्ट्रैक्ट में एनफोर्सेबिलिटी होती है। ऑल एग्रीमेंट्स आर नॉट कॉन्ट्रैक्ट बट ऑल कॉन्ट्रैक्ट्स हैव टू बी एन एग्रीमेंट। पर एग्रीमेंट मे और मे नॉट बी एनफोर्सेबल बाय लॉ, बट कॉन्ट्रैक्ट इज ऑलवेज एनफोर्सेबल बाय लॉ। Okay, what are the various types of contract? Well, types of contract में express contract होता है। express contract is a contract where the words spoken and written. उसके बाद अपने पास implied contract होता है। yes, implied contract ये होता है या contract which is made otherwise than by words spoken, ये implied होता है, conduct से होता है। जैसे आपने टैक्सी रोक लिया, आपने बस चढ़ लिया, वो implied contract है। ई कॉन्ट्रैक्ट्स के टर्म, ई कॉन्ट्रैक्ट्स क्या होते हैं? ई कॉन्ट्रैक्ट इलेक्ट्रॉनिक मोड के कॉन्ट्रैक्ट है। इट इज अ बाय प्रोडक्ट ऑफ द ई कॉमर्स टुडेज वर्ल्ड। इट इज डेवलप्ड बिकॉज ऑफ द स्पीड, efficiency and convenience in the today's world. Instead of being a usual paperwork, now these kind of contract are widely followed. ओके, एग्जाम्पल आप देख सकते हो, अमेजोन पे खरीदना, फ्लिपकार्ट पे खरीदना। What is the valid contract? Well, valid contract is a contract which is entered between the parties to satisfy the elements of the contract. That is the valid. What is the void contract? Void contract का मतलब होता है a contract which ceases to be enforceable by law and it is void in nature. So contract which is not enforceable by court is a void contract. Voidable contract. Okay, voidable contract. Contract is entered without any free consent of the party. It is considered as voidable contract. और इस contract के अंदर enforceability हो भी सकती है, नहीं भी हो सकती है, depending on the option of the parties. जहां पे जिसके साथ कोई गलत काम हुआ है वो डिसाइड करेगा कि वेदर आई वांट टू एनफोर्स द कॉन्ट्रैक्ट और नॉट। अब हम बात करते हैं क्वाजी कॉन्ट्रैक्ट। क्वाजी कॉन्ट्रैक्ट एक कंस्ट्रक्टिव कॉन्ट्रैक्ट होता है। क्वाजी कॉन्ट्रैक्ट इज नॉट अ रियल कॉन्ट्रैक्ट, इट्स नॉट द ट्रू नेचर ऑफ द कॉन्ट्रैक्ट। Quasi contract is based on the intention of the parties. Okay, quasi contract lack one or more of the essential terms of the contract, principal, equity वगैरह नहीं होते। फिर बात करते हैं कॉन्ट्रैक्ट इन राइटिंग। वेल, कॉन्ट्रैक्ट क्या होता है? कॉन्ट्रैक्ट एक्ट जो है, इट नेवर स्पेसिफाइज द वर्ड कॉन्ट्रैक्ट एज सच। कि कॉन्ट्रैक्ट हमेशा राइटिंग में ऐसा कहीं नहीं लिखा। ओरल कॉन्ट्रैक्ट्स कैन ऑल्सो बी वैलिड, बट यहाँ पे ओरल कॉन्ट्रैक्ट्स प्रूव करना अपने आप में बहुत डिफिकल्ट होता है। दैट इज द रीजन वाई वी ऑलवेज फॉलो द कॉन्ट्रैक्ट हैज टू बी इन राइटिंग। Okay, let's try and understand what is the void contract and a voidable contract. Well, void contract का मतलब ये हो जाता है that is the contract ceases to be enforceable. लेकिन voidable में एक agreement enforceable रहता है, maybe within a year or two, depending on the nature of the contract. यहाँ पे void contract के nature की बात करो तो valid contract void होने के बाद enforceability खो देता है, लेकिन voidable contract valid हो सकता है, okay, until it is cancelled by the party. What about the rights and remedy? Well, no legal remedy is there in void contract, but aggrieved party can have a legal remedy in a voidable contract. What about performance of the party? Party can't demand any kind of performance in the void contract. Like, yes, if the aggrieved party does not cancel the contract within the reasonable time, then voidable contract becomes enforceable. And reason की बात करूँ तो void contract becomes void due to changes in circumstances. लेकिन voidable, if the consent is not obtained freely, then it is voidable in nature. And the damages की बात करो, well, void contract with the party does not have any right of damages, लेकिन voidable contract में party can demand certain damages. ठीक है, नेक्स्ट आता है वॉइड एग्रीमेंट, इलीगल एग्रीमेंट। ये भी अपने आप में काफी फेमस रहा है। वॉइड एग्रीमेंट, इलीगल एग्रीमेंट। ओके, वॉइड एग्रीमेंट, एग्रीमेंट दैट इज हैज नो लीगल इफेक्ट इज वॉइड। इलीगल एग्रीमेंट, इट इज अनलॉफुल एग्रीमेंट विच इज इलीगल एग्रीमेंट। वॉइड एग्रीमेंट हमेशा इलीगल नहीं होते। इलीगल एग्रीमेंट काफी हद तक वॉइड भी होती है, क्योंकि वो तो वॉइड ही रहते हैं। Well, parties to the void agreement can move to the court, लेकिन parties to illegal agreement cannot move to the court। मतलब अगर आप किसी को खून करने का कॉन्ट्रैक्ट देते हो तो वो कोर्ट में जाके एनफोर्स नहीं हो सकता, लेकिन parties to void contract can move to the court। Well, sometimes valid contract can become void subsequently, लेकिन illegal void ab initio रहते हैं। And collateral ancillary transactions void contract में नहीं होता, लेकिन वो collateral ancillary transactions to the illegal contract is not at all enforceable। Okay, the contract which becomes void under the Indian contract, what is the essence of the agreement that is ought to be free consent? Well, free consent एक बहुत ही essential terms है contract के हिसाब से। An agreement which is not enforceable by law वो अपने आप में void होता है, ठीक है। नेक्स्ट होता है कि contract which ceases to be enforceable by law वो void हो जाता है। Contract which becomes void by the reason of certain event where the promisor is not able to perform his function वो भी void हो जाता है। Whether contract बिकम्स वाइड बाय रीजन ऑफ सब्सिक्वेंट इलीगैलिटीज, मतलब आपने किसी से कॉन्ट्रैक्ट किया तो गवर्नमेंट ने वो डील ही कैंसिल कर दी, उससे डील करना ही मना कर दिया। हमारे काफी सारे जो व्यापारी वर्ग हैं वो लोग जानते हैं कि चाइना से इंपोर्ट की डील करी थी और वो कैंसिल हुई थी। देन कंटीजेंट कॉन्ट्रैक्ट्स की बात करें तो डू और नॉट टू डू समथिंग और अनसर्टन इवेंट, तो जब वो कंटीजेंसी फेल होती है आपका कॉन्ट्रैक्ट अपने आप में खत्म हो जाता है। एंड वेयर अ कॉन्ट्रैक्ट इज वॉइडेबल एट द ऑप्शन ऑफ द एग्री पार्टी एंड द पार्टी हैज एक्सरसाइज द ऑप्शन, इट इज वॉइड। ठीक है, डिस्कस द रूल ऑफ ऑफर। वेल, रूल ऑफ ऑफर के बारे में बात करूं तो देयर मस्ट बी टू पार्टीज, कम्युनिकेशन ऑफ ऑफर होना चाहिए, विलिंगनेस होनी चाहिए, you have to view the assent of the other party, it has to be very definite, unambiguous, certain, it should create a legal relationship, it should be kind of offer जहाँ पे सामने वाले से acceptance बने। mere invitation नहीं होना चाहिए। what is the invitation? invitation का मतलब ये होता है कि आप सामने वाले से ऑफर एक्सपेक्ट कर रहे हो, जैसे कैटलॉग ऑफर, प्राइस, मेन्यू कार्ड, जिसमें सामने वाला एक ऑफर देगा और आप उसको एक्सेप्ट करोगे, तो एक तरह का इन्विटेशन होता है। Okay, now when offer comes to an end, well, offer comes to an end either by the notice of withdrawal, either by lapse of time, either by counter offers, either by acceptance of the parties on death or insanity, or rejection of the offer or any of such nature. What are the provision of acceptance of offer? Well, like offer can be accepted in many ways. By the way, डिपेंडिंग ऑन द नेचर ऑफ ऑफर इसका एक्सेप्टेंस डिफाइन होता है। एक्सेप्टेंस शुड बी एब्सोल्यूट एंड अनकंडीशनल। एक्सेप्टेंस हैज टू बी कम्युनिकेटेड। मियर मेंटल एक्सेप्टेंस कैन नॉट बी एन एक्सेप्टेंस। जनरल रूल ऑफ एक्सेप्टेंस क्या है? एक्सेप्टेंस मस्ट बी मेड इन द मैनर इन विच द ऑफरर हैज आस्क्ड यू टू डू द एक्सेप्टेंस। जैसे ICSI अगर आपको बोलता है स्पेसिफिक नेचर में आपको फॉर्म फिल करना एग्जाम का, तो उसी नेचर में एक्सेप्ट करने का। व्हाट इज द एक्सेप्टेंस इज नॉट मेड एज पर द मेथड प्रिस्क्राइब? वेल, ऑफर कैन ऑलवेज बी रिजेक्टेड इफ इट इज नॉट मेड इन द मेथड प्रिस्क्राइब। एक्सेप्टेंस इज डन बाय whom? But in case of specific offer, the acceptance has to be done by the specific person. In case of general offer, the acceptance can be done by any person who meets the condition. Okay, can the silence be acceptance? Well, silence cannot be acceptance. What is the time limit for making the acceptance? Acceptance should be made within the prescribed time. अगर वहाँ पे time दिया है तो offer is not accepted within the time limit, then the offer lapses. Acceptance अपनी तरफ में express भी हो सकती है, implied भी होती है, depending on the conditions of the offer. Very good. Distinguish between offer and invitation to offer. So offer में there is a proposal, there is a willingness to do something. Invitation में there is an invitation that I need an offer in that case. Offer is made by the person who enter into the contract. Invitation is made by the person who intends to receive the offer. Offer accepted, agreement हो जाएगा. Invitation accepted, offer हो जाएगा. Okay. State the difference of rules before the acceptance of the offer. In the acceptance of the offer, when the mode of making the varies from the post to telegraph to emails, which is governed by the information technology. मतलब एक क्वेश्चन आपसे बोल रहा है कि अगर एक पोस्ट होगा, अगर एक टेलीग्राम होगा, अगर एक ईमेल होगा, तो ऑफर एंड एक्सेप्टेंस कैसे चलेगा? वेल, ऑफर इज कंप्लीट व्हेन देयर इज अ एक्सेप्टेंस by the offeree, when it is made in the method which is prescribed. In case of acceptance by the post, acceptance has to be complete when the valid contract is concluded, when the letter has been accepted. जब ऑफर आपका टेलीफोन या ईमेल से जाएगा तो इट इज कंप्लीट व्हेन द कॉन्ट्रैक्ट इज एक्सेप्टेड बाय द अदर पार्टी, जब वो सामने वाले के नॉलेज में आ जाएगा। ईमेल एक्सेप्टेंस टेक्स प्लेस एज सून एज जब वो सामने वाले को मिल गया, और इन्फॉर्मेशन टेक्नोलॉजी उसका टाइम एंड डेट ऑफ डिस्पैच नोट करता है। ठीक है, नाउ हु आर कॉम्पिटेंट टू एंटर इनटू कॉन्ट्रैक्ट एंड व्हाट नेचर, दैट हैज टू बी सीन। लेट्स सी दैट। So in that case, competency की बात करो तो in case of capacity, it means that the competency of the parties, it means that the legality to enter into contract. Well, इस केस में माइनर की बात करो तो माइनर और कि हिसाब से कैसे होगा? वेल, मेजॉरिटी एक्ट के हिसाब से पर्सन हु इज द एज ऑफ 18 years कैन एंटर इनटू कॉन्ट्रैक्ट। लेकिन इंडियन मेजॉरिटी एक्ट के हिसाब से अ पर्सन हु इज नॉट हैविंग एनी काइंड ऑफ गार्डियन और गार्डियन व्हिच इज अपॉइंटेड बाय द कोर्ट, इन दैट केस दैट पर्सन अटेन्स द एज ऑफ 21 years. Now, what is the effect of minor's contract? Well, agreement with the minor is void ab initio. An agreement with the minor can never be enforced with the other party. The famous case of Mohri Bibi versus Dharmadas Ghosh. So D was the minor, he borrowed the money from M, executing a mortgage in the favor of his property. M later on failure to make the payment. It was held that the agreement is void ab initio and the money cannot be recovered. M was ordered to release the house from the mortgage, and the court has explained that the minor cannot be promisor, he cannot be a promisee also. Okay, but he can't be a promisee. So इससे कई सारी बातें निकल के है. Let's see and understand one of them. Can a minor be a promisee or a beneficiary? Well, minor can be a promisee. Okay, here थोड़ा सा चेंज कर लेना. He can be a promisee, can't be नहीं आएगा. So he can be a promisee, that is minor can be a promisee in this case. What about ratification? Well, minor contract is void ab initio, लेकिन ratification means an acceptance of a transaction which is already done. तो मुश्किल होगा. What about specific performance? Well, actually आप minor से कभी कोई specific performance demand नहीं कर सकते. As a minor, you cannot be a promiser, so you cannot make any kind of specific performance. What about restitution order? Restitution मतलब अपनी चीज वापस मांगना. So restitution order against minor, yes, that can be passed. अगर minor से आपसे कुछ चीजें लिए और आप वही चीज वापस मांग रहे हो, बिल्कुल मांग सकते हो. What about contract by the guardian? Well, in case of minor, the contract is generally done by the guardian. The contract should be for the benefit of minor. The guardian should be authorized in this case. And the contract which is entered by the guardian for the benefit of the minor, neither the guardian nor the minor is liable in that case. Okay, only the assets of the minor can be liable. Is minor liable for necessaries? Yes, minor assets are liable for necessary. Minor is not personally liable for necessaries. Okay, what are necessaries? Necessary things are those things which are necessary for the existence of the life of the minor. So that thing has to be taken care. Plus, minor is not already in the possession of necessities, then the necessity should be given to that minor. Okay, so इन चीजों को ध्यान रखना. Oh, consideration, very important topic again from Indian Contract Act. Consideration होता क्या? Consideration moves at the desire of the promisor towards the promisee or any other person to person who has done or abstained from doing, does or abstain from doing, do or abstain from doing something, and that act or abstinence is a consideration. Okay, लेमन टर्म में बात करो तो क्विड प्रो क्यो, समथिंग इन रिटर्न, मुझे क्या मिलेगा, दैट इज कॉल्ड एज कंसिडरेशन. एलिमेंट ऑफ कंसिडरेशन में क्या क्या चीजें ध्यान रखना? वेल, एलिमेंट ऑफ कंसिडरेशन में ध्यान रखना, इट हैज टू बी, इट कैन बी एक्ट और एब्सटिनेंस, इट कैन बी इन कैश गुड्स, इट कैन बी पास्ट प्रेजेंट फ्यूचर, इट कैन बी एट द मूविंग एट द डिजायर ऑफ द प्रोमिसर. कंसिडरेशन मे बी लॉफुल और इलीगल कंसिडरेशन वैसे भी अलाउड नहीं होता, वो अपने आप अवॉइड होता है. कंसिडरेशन कैन बी पास्ट प्रेजेंट और फ्यूचर. इवन फोरबेरेंस एब्सटिनेंस कैन बी कंसिडरेशन. फोरबेरेंस मतलब खुद को रोकना, ये काम नहीं करना. Consideration need not be adequate. Consideration cannot be impossible also. Consideration cannot be illusionary, but consideration has to be certain in all cases. And if the promisor is anyway legally bound to do something, then he agrees to do, then he has to do it. Remember, consideration अपने आप में ऐसा होना चाहिए कि सामने वाला वो काम कर पाए. Can a contract without a consideration be there? Yes, there can be there. There are certain exceptions to the consideration. On account of love and natural love, you can have a contract. You can have a contract based on voluntary services that has been rendered. You can have a time bar promises that can be performed. You can have completed contracts that can be performed. Even agency can be there without a consideration. So that depends on the nature of the contract, where consideration at times is required, where consideration at times is not even required. Okay, what exactly is a privity of contract? Privity का मतलब होता है दो पर्सन के बीच में जब एक कॉन्ट्रैक्ट होता है तो उसके कॉन्ट्रैक्ट के बीच में जो एक दूसरे का आपसी विश्वास और ट्रस्ट है वो कैसे बनता है, उसी की वजह से कॉन्ट्रैक्ट प्रिविटी लेता है. तो स्ट्रेंजर्स आर नॉट अलाउड एक्चुअली. दैट्स अ वेरी फेमस ट्रीटमेंट. So a stranger to the contract cannot sue for the want of privity. The person who is a party to the contract cannot. A person who is a party to the contract can only sue for the contract, not outsiders. Okay. So reasons for existence of privity. Privity का reasons क्या था? Well, अगर कॉन्ट्रैक्ट में हम लोग बाहर वालों को इन्फोर्स करने को दे दे तो फिर इस तरह से कॉन्ट्रैक्ट कभी भी एग्जीक्यूटेबल नहीं होगा. हमेशा एक डर लगा रहेगा कि वो उसने ये कर दिया, उसने ये कर दिया. So that is the reason why third party did not provide any consideration. They have no right to sue, and it will be unjust to sue upon a contract where you are not even a party to the contract. A non-contracting party cannot be made. Can be given a benefit of the contract, but you can say a non-contracting party cannot enforce the terms of the contract, and it will be really unfair to call upon the promisor for two actions, one which can be done by the party to the contract and one which can be done by third party. Okay, and then you can discuss with various example. Now, do we have exception to the privity rule? Yes, we do have exception to the privity rule. Say for example, in case of a trust, the beneficiary can sue, because even though there is no privity, yet the beneficiary is the one for which the trust is executed. So also in case of assignments, assignees can sue for the contract. Family arrangement mein any member of the family party can sue for the contract. Where there is a acknowledgement of the liability by the third party, yes, even then a person can sue the third party for recovery of the acknowledgement, recovery as per the acknowledgement. And when a person makes a promise for the benefit of a third party, well, then in that case the promisor can be sued. And in case of estoppel, especially where the partnership is there, so in case of estoppel, when the act of one of the partner has been done, so the other party can sue for this contract. What do you mean by coercion, undue influence? Well, coercion, undue influence, by coercion is the act where there is a threat. Undue influence is act where influencing the other party. When you talk about pressure, coercion has a psychological pressure or even a physical pressure. Undue influence में there is a mental or a moral force. Coercion के अंदर आप बात कर सकते हो, you can compel the other party to enter into any kind of contract. लेकिन undue influence में there is an unfair advantage. Criminal nature की बात करो तो coercion, yes, it is of criminal nature. Undue influence, no. आगे रिलेशनशिप की बात करो तो कोवर्जन में द रिलेशनशिप बिटवीन द पार्टी इज नॉट नेसेसरी, लेकिन अनड्यू इन्फ्लुएंस में यस देयर इज अ रिलेशनशिप बिटवीन द पार्टीज, इट इज नेसेसरी इन दिस केस. ठीक है. फ्रॉड एंड मिसरिप्रेजेंटेशन. ओके, फ्रॉड क्या होता है? वेल, फ्रॉड इज एन एक्ट वेयर यू आर ट्राइंग टू डिसीव द अदर पार्टी बाय एंटरिंग इनटू द कॉन्ट्रैक्ट. You're giving a falsehood suggestion. You're making a promise which you are not likely to execute. You're omitting some relevant facts which can cause a fraud. Okay, whereas misrepresentation is just a false statement where you honestly believe it to be true, then it's a misrepresentation. Intention to deceive, well, fraud is a deliberate or willful act, whereas misrepresentation, it's an innocent or a wrongful act. When you talk about belief in fraud, the person making the falsehood statement does not even believe, but in misrepresentation, the person making the statement, he believes it to be true. Remedy की बात करो तो yes, for fraud के अंदर it entitles the agree party to seek the remedy against the person. And misrepresentation, you can have a remedy only to claim the damages, nothing further. Punishment की बात करो तो Indian Penal Code also imposes punishment for fraud, but misrepresentation, it's not a criminal act as such. Okay, what is a mistake? Yes. Ignorantia juris non executor. Mistake का मतलब क्या? Mistake मतलब some kind of erroneous belief. मुझे ऐसा लगता है. Okay, so assumptions पे नहीं रहने का, because it causes mistake. And criminal law recognizes the ignorance of fact may be an excuse, but ignorance of law is not an excuse. इसी को बोलते हैं ignorantia juris non excusat. Okay, mistake can be of law, mistake can be of fact. Mistake of law can be of Indian law or foreign law. Well, contract can neither be void or voidable due to the mistake of Indian law because it is penal. However, if you mistake a foreign law, it is a mistake of fact. And nothing is an offense which is done by the person who is or who was, by the reason of the mistake of the fact or by not reason of any kind of law, in good faith टू डू समथिंग. मतलब अगर मुझे लगता है कि मुझे ऐसा करना चाहिए था और मैंने सच्चाई में अच्छी चीज़ की है, उस टाइम पे उस तरह का कोई लॉ एग्जिस्ट नहीं करता था, तो वो अपने आप में कोई मिस्टेक तरह के काउंट नहीं की जाएगी. वो इंडियन पिनल कोड भी इंडियन कॉन्ट्रैक्ट एक्ट क्लियर करता है. अब मिस्टेक ऑफ फैक्ट क्या होता है? मिस्टेक ऑफ फैक्ट आप बायलैटरल मिस्टेक और यूनिलैटरल मिस्टेक दो पार्ट्स में डिवाइड कर सकते हो. एक एरोनियस ओपिनियन कि मुझे ऐसा लगता है, सो दैट इज कॉल्ड मिस्टेक ऑफ फैक्ट. मुझे ऐसा लगता है. ओके, सो इट इज द एरोनियस ओपिनियन that result into this kind of mistake. Bilateral mistake by very agreement, it is void. Unilateral mistake by its very agreement, it is voidable in nature because it depends upon the other party to make the contract void or not. Okay. What is the next one? Oh, what are the various flaws of the contract? Flaws means जो contract में कमियां हैं जिसकी वजह से contract पूरी तरह affect हो सकता है. Well, it can be voidable or void depending on the flaws. So agreement is treated to be void if there are flaws in the contract, and the law gives an aggrieved party a chance of cancelling the contract or claiming any kind of damages, and the guilty party can be held liable for such flaws. So what are the main flaws? Incapacity of the party, mistake, misrepresentation, fraud, coercion, illegality, impossibility. These are the flaws. Okay, what do you mean by restraint of trade? Well, restraint का मतलब होता है एक तरह से रोकने का. तो agreement in restraint of trade, either it's by very much means void in nature, but a lawful restraint can be there depending on the nature of the context. Say for example, partners agreement, service agreement, sale of goodwill agreement. Lawful restraint can be there for certain period, certain region. That restraint is valid in law. Okay. And what about agreement which is unlawful? Well, agreement unlawful, where the lawful part can be separated from the unlawful part, then lawful part is valid and the unlawful part is cancelable. Where the lawful and unlawful part cannot be separated, when the object itself is void, the entire agreement becomes void. Reciprocal promises to do a legal and illegal thing. Well, in case of reciprocal promises to do the legal and illegal thing, in the specified circumstances, if you can separate the promises, it's legal. Otherwise, the whole contract is illegal. Alternative promises where one branch is illegal. Well, in case of alternative promises where one branch is illegal, then the illegal branch cannot be enforced, whereas the legal branch can be enforced. However, if the entire contract cannot be enforced, then it becomes illegal. What do you mean by wagering and contingent contract? Well, wagering and contingent wager. Wager means winning or losing upon this uncertain event. Contingent is also an uncertain event, but there's no question of winning or losing. A wagering may there is an uncertain event which can be past or future, but contingency may there is always a future-based uncertain event. Legal effect की बात करो तो wager is a void agreement, whereas contingent agreement is a valid agreement. And betting is one of the favorite example of wagering, whereas contingent contract में insurance comes. Okay, promises and performances. So promiser can perform the promise when he has intention to promise, when he involves in the personal skill, and when he has invoice of the personal trust and confidence. That's when we expect the promiser to perform. मतलब आपने अगर कॉन्ट्रैक्ट लिया तो आप ही को परफॉर्म करना पड़ेगा. ये 3 कंडीशंस की बात हो गई. लेकिन अगर आपकी जगह पे कोई और परफॉर्म्स करना आता है तो इसका मतलब उसके स्किल्स की बात हो रही है. ठीक है. Now, what is the liability of a joint promiser? In the absence of any kind of contract, the promise may be that is, a promisee may compel one or the more person to be a joint promiser. In each of the joint promises may compel the joint promiser to contribute equally to himself or to any other person. In case of joint promise, क्या रहता है? There is a compelling. And if any of the joint promiser makes a default in the contribution, the remaining joint promiser bears the loss arising in this case. Okay, a release of the joint promiser promises does not get discharged in this case. Okay. Then what is the discharge of a contract? Well, discharge of a contract मतलब ये रहता है that is contract अपने आप में एक तरह से terminate हो गया. So what are the ground of discharge? Discharge का ground हो सकता है that is by performance, by mutual consent, by impossibilities, by operation of law, by lapse of law, or by any kind of breach of contract. So what do you mean by novation and alteration? Novation का मतलब होता है something new has been done. Alteration का मतलब होता है there is a change. When a new contract is entered into novation, yes, there is a new contract entered into novation. And are the parties different? Yes, in novation the parties are different, parties are not the same. And what are the changes in the term may or may not be enforceable depending on the nature of the parties. What do you mean by rescission and alteration? Well, rescission का मतलब होता है cancellation और alteration का मतलब होता है जहाँ पे आपने terms alter किया है. How does it take place? Well, it takes place as per the mutual consent of the parties. So alteration can take place without even mutual consent of the parties. What is the effect? Rescission is contract ended, whereas alteration, parties are legally bound to enforce the contract unless you have altered the terms in a different way. Okay. Then we come to discharge of the contract, impossibility of performances. See, there are 2 types of impossibility: initial impossibility, supervening impossibility. Initial impossibility is where you are known that you will not be able to enforce the contract. The initial impossibility is a known or an unknown impossibility. When it is unknown impossibility, it is a supervening impossibility. Supervening impossibility is coming from doctrine of frustration. That means a contract is void ab initio and the act should become impossible to perform. And the impossibility of should be of such a nature where you cannot do anything about it. The impossibility can be result out of negligence or result out of something where the promiser himself cannot perform as part of the contract. It can be a destruction of the subject matter, one of the example, or illness, death, or something of act of God, or you can say performance arising of any other nature which has become impossible. But not every impossibility is a supervening impossibility. In that case, what is not a supervening impossibility, where the performance of the contract becomes difficult, or even the commercial impossibility or default of the third party, strikes, civil disturbances, civil inducements, a failure to perform the contract, that is not a supervening impossibility. Hey, what is breach of contract? What is the anticipatory? Breach of contract means failure to perform as part of the contract. Anticipatory breach can be actual breach or anticipatory breach. Actual breach of the contract, when one of the party to the contract has failure to perform as part of the performance of the contract and you can accept that he is not performing the part of the contract, then it's an actual breach. The consequences are, well, time is the essence of the contract, then you can the contract can be voidable and you can claim compensation for the non-performance. If time is not the essence, at the max you can claim only the compensation but nothing for the losses. Anticipatory breach की बात करो, that you anticipate something can go wrong in this case. Well, what are the consequences? Well, in this case, the aggrieved party can treat the contract as alive till the time of actual breach is coming into picture, or you can resign the contract in between itself and claim the damages till the date of resigning the contract. Okay, what do you mean by suit for damages? Damages means something kind of monetary money that you claim, and the purpose of damages is to not to punish the other party, but to recover the losses from the other party. Ordinary damages can be there; it arises out of natural terms of the contract. Whatever loss that you have suffered, you can ask for the damages. Special damages can also be there. If there are special damages will result in the loss, that can be claimed. Vindictive damages are also there. These are called exemplary punitive damages. जिसको बोलते हैं ना मेरा नाम बदनाम कर दिया. So vindictive damages can also be there, and there can be punishment, and breach of the contract can be there, or wrongful act of dishonor of check, that can be giving a vindictive damages. Nominal damages is there. Nominal damages acknowledges the fact that plaintiff has won the case, and that is why the court is giving a kind of damage. Damage can for inconvenience, something called discomfort, mental agony, that can also be there. Liquidated damages can be there. Yes, it specifies the amount of entering into the contract. You can before entering into the contract, you can specify the amount. If the contract fails, I will claim so much from you. That is called as liquidated damages. And if the contract actually fails or breaches because of the consequent act of the other party, you can claim such kind of damages. Payment of interest can also be there. Well, it is agreed between the parties, and if the interest of the it is in the nature of the party to enforce the contract. The suit can be for decree, and the court has to pass the decree. What do you mean by quantum merit? Quantum merit means as much as it is earned. Okay, so here in quantum merit, where the court has become impossible to perform and the contract has become void, it suffers from quantum merit. Now, who can claim the quantum merit, and what is the outcome of this? Quantum merit means whatever is the loss, I will repay the loss. Something in nature of insurance that happens. So when one party prevents the other party from completion of the contract, or it becomes void because of completion, before the completion, or the agreement is discovered to be a void agreement, then the claim of quantum merit can arise. Okay, and the contract, if it is divisible, the part which can be performed should have been performed, and the one which cannot be performed, you can claim compensation for that. Okay, and what was the difference between quantum merit and anticipatory breach? Well, quantum merit is as much as may be earned. It is used where the person claims a reasonable remuneration for the services which he has rendered. There is no express promise as such, and the law implies that such kind of compensation can be rendered to the party if the circumstances show that these are paid. Anticipatory breach क्या होता है? There is a before contract is performed, you're anticipating a breach, and the parties definitely renounces the contract and shows that he has no intention of performing the contract. The other party on the breach, when happens, he can claim the damages. He may either sue for the breach of the contract or after repudiation, or he can wait till the actual contract is getting over, till the performances are done or not. He can remain liable, and the promisor is not only the promisor is not only liable for completion of the contract, but if he fails to complete the contract, in that case there is a repudiation, and he can avail himself an excuse that he was not able to perform the contract. So in anticipatory breach, you always anticipate there is some kind of circumstances whereby this contract cannot be performed. Okay, so these are the two things that is there. And now we come to indemnities and guarantees. Indemnity, 2 parties. Indemnify. Guarantee, 3 parties. You can call surety, principal, debtor, or something like that, or indemnify, and surety. Okay, liability in terms we talk about liability. The liability of the indemnifier is primary. The guarantee and the liability of surety is primary. Number of contract, there is only one contract between the indemnifier and indemnified. There are 3 contracts, that is called principal debtor relationship, debtor creditor relationship, and surety. What about suit? Well, indemnifier cannot sue, and the surety can discharge the contract. What about the nature of debt? Well, the liability of the indemnifier arises only on happening of the contingency, whereas in guarantee, there is a liability where arises where the principal debtor fails or existing debt fails. Now, what is the request? It is not necessary to make a request to the indemnifier because he knows that there is a liability. Well, it is necessary to make a request to the surety in that case. Now, what is the continuing guarantee? Well, according to 129, when a guarantee is extended to a series of transactions or distinct transactions which are separable from each other, these kind of guarantee is a continuing guarantee. A guarantee gives an intended coverage to the transaction over the period of time. The intention is to enforce the contract. Well, in this case, a continuing guarantee can be revoked by notice, by death, by any kind of variation of terms, or creditor's omission, or any kind of novations. Okay. What do you mean by bailment and pledge? Bailment means where you hand over your goods to some other person for the specific purpose, for the specific possession. It is a bailment. What is the pledge? Pledge implies any kind of contract, any kind of article which is deposited with the person against the who is a lender against the security as a debt. So bailment is defined in 148, pledges 172 parties. Well, there is a bailer and the bailee relationship. Pledgement, there is a pledger and a pledgee relationship. Consideration in bailment may or may not be there. Pledge always has. And the bailee may use the contract for the specified purpose. The pledgee cannot use the goods for a specified purpose. Lien, bailee has certain right of lien. Pledgee has a right to sale if there is a breach of contract. And nature, all bailments are not pledged, but all pledges had bailment as except the specific amounts that we have covered. Okay. Now let us understand further. What is a gratuitous bill and what is the bailment for reward? Well, gratuitous bailment. Gratuitous means the things that you do free of cost. आप किसी से कुछ पैसा नहीं लेते हो. So gratuitous bailment is that which is neither the bailer nor the bailee gets any kind of remuneration. Bailment for reward is मैं तुम्हारे लिए काम करूँगा, मुझे पैसा चाहिए. So there is a bailer-bailee relationship and you are doing a bailment in that case. Safety of goods. Well, it is the duty of the bailer and bailee to keep the goods safe in both the cases, be it gratuitous, be it bailment for reward. Liability of damages. Bailer is not liable for damages which is caused due to the fault of the goods, but the bailer has to inform the bailee about the goods. The bailer, in both the cases, it is irrespective of that. Right of restoration. Well, bailer has a right to restore the goods. He can demand back his good, even though it is gratuitous bailment. He can demand back his good, and he has a. If he has lent it for the fixed time, then he can demand it back. Well, in bailment for report, the bailer has a right to demand the restoration of goods which he has lent it at any time, and for the specific period or for specific term. What about dangerous goods? Well, if the goods are dangerous in nature, the bailer has to disclose it, and be it reward or be it other way, it has to be disclosed. Okay. What about general lien and particular lien? Well, general lien is a right which is created on all the kind of goods and the other party until all the claims are satisfied. Well, particular lien is a right created based on some kind of skills or some kind of labor that has been done. In general lien, the right on the goods is for the security, for the balance, something like factors, hire purchase, brokers, or attorneys of the High Court. In particular lien, the bailee has a type of particular lien which is created by the agreement between the parties. What about sale and bailment? Well, in case of sale, the ownership is transferred, whereas in bailment, the ownership is never transferred. Okay, under bailment, you can say the goods are delivered for specific purpose. The goods are not delivered for specific, it's sold. Okay, that's a basic difference. What about finder of the goods? Well, the finder of the goods is the bailee. Yes, it is. So after the purpose is over, after you found the goods, you have to return back the good. So if you are a finder of the goods, you have found something on the roads or somewhere else, there is may not be an express contract, but there is an implied contract that you have to find the owner of the goods and you have to return the goods back to the owner. And in this case, the Indian contract says the person who has found the goods, okay, he has to return it. And for returning purpose, you can do all the necessary expenses to find the true owner. If anybody takes the property from you, you can sue the other party for taking away the property, and you have all the right of finding, retaining, and maintaining and securing the goods. And the finder of the goods, lost goods, can sell the goods if the owner is not found, even after due efforts, or you have spent more than 2/3 of the value of the goods, then you can sell the goods. Okay. What do you mean by agency by ratification? Ratification means a kind of affirmation, a kind of confirmation. So a person can be agent without authority also. Agent has to be acted on the principle. Agent must have a contractual capacity. It has to be ratified by the contract. It should be within the reasonable time. It should be done as a whole act. It should be communicated. It should put the third party to damages. When can the agency be revocable? Agency becomes revocable when some kind of events happens. Okay. Now, however, in certain nature, the agency are not revocable. When the agent has an interest in the authority of the agency, then it cannot be revocable. Or you can say agency which is coupled with the interest of the property. In case of any kind of death or insolvency also, it cannot be terminated because agent has invested something in that. Agent has a personal liability, it cannot be revoked. Where the agent has exercised an authority as per the terms of the agency, it cannot be revoked. Now, distinguish between a sub-agent and substituted agent. Well, sub-agent works instruction of the agent, whereas substituted works instruction of the principal. Sub-agents, there is no privity of contract between the principal and the sub-agent, but there is a privity of contract between the principal and the substituted agent. Sub-agent cannot sue for the remuneration or the commission. Substituted agent can sue for the remuneration or commission. Responsibility, agent is responsible for the act of sub-agent, and substituted agent, the agent is not responsible for the act. Agent is not responsible, rather principal is responsible for the act of substituted. What do you mean by Uberrima Fidei contract? Well, contract of utmost trust. आप पे पूरा विश्वास है. That kind of contract is called uberima fidaiko. The failure of the party to disclose the information in the contract is voidable at the option of the other party, and such kind of contracts are uberima fidaiko. Like contract of insurance, the assured must disclose all the material facts which is there in his knowledge. Prospectus, the company has to give all the required statutory obligation and things which is there in the company. Any person who is investing in the company should make the decision on the basis of this, and if it is not there, then he can claim the damages for material false statement which is made. What about contract of sale of land? Yes, the vendor has to give you all the details that if he's selling the land to show a good title exists. What a family arrangement? Well, the members of the family has to state every particulars of this agreement. Okay, so hope I have done the entire thing फटाफट. So Indian Contract Act फटाफट. Okay, so अच्छे से एग्जाम के लिए याद करना, and we will see you on the other side with lot more to come. Bye bye. All the best for exam.